This is Kevin McNeely. I'm providing an IP law update on a district court decision involving the requirements to satisfy virtual patent marking under Section 35 U.S. Code 287. 35 U.S. Code 287 requires that patented articles be marked in order to collect pre-lawsuit damages. Effectively, it is a way to create constructive notice in lieu of having actual notice when filing a lawsuit. So I'm providing an example of physical marking under the statute. As you can see, this is a magazine cartridge for a firearm, and it's marked with U.S. patent number 6560907. As you can tell, it can have a number of issues with respect to properly marking the product, including limited space, along with what to do when patent numbers change and other issues that may arise. In 2011, the AIA amended Section 287 to provide for virtual marking. Virtual marking, the words patent or PAT period, are provided on the product or on its product packaging, along with a web address that's accessible to the public. So the actual patent numbers can be in a listing on a web address that's associated with the product. The District Court of Delaware is probably one of the first courts that has dealt with compliance with virtual patent marking requirements in a case Manufacturing Resources versus Civiq Smartscapes, in a decision issued on summary judgment on August 28, 2019. So this case involved a patent that was marked with a website address, and from the court exhibits, I'm providing what was actually available at the website address. So there was a list of 99 patents, 77 U.S. patents provided at that website address. And these, obviously, this is not the actual website. This is the exhibits from the court documents. There was a listing of patents, which is effectively about 12 pages of patents, as you can see. At the bottom of that listing was a statement that one or more of the above listed MRI patents may be used by LG MRI products under license from MRI Inc. So no direct association between a product and a patent, and nothing specific in terms of what patents specifically cover what particular products. The court found that this was not something that complied with the requirements for patent marking. The website must associate the patented article with the number of the patent, and the notice provided to the public must be commensurate with that of physical marking. A mere direction to a general website listing of patents for all products was found not to create this association. The court also noted that permitting this practice would likely create issues of false marking if association could be inferred solely from a list of patents that may apply. So, in essence, simply listing all patents that could apply to a product does not give proper public notice. Some practice considerations. Obviously, failure to properly mark can have consequences, and those consequences are the inability to collect pre-lawsuit damages for patent infringement. Now, virtual marking should be easier to maintain in comparison to physical marking. The patent webpage simply needs to be accessible to the public without requiring a fee or payment. and the patented article should be easy to locate on the web page. A question that could arise is, this is the first decision by a court on the new virtual patent marking statute, 35 U.S. Code 287A. So there are likely to be future decisions, and it remains to be seen if there could potentially actually be higher standards in terms of what's required for virtual patent marking. If you consider that it's much easier to maintain virtual marking than it is to actually physically mark a product. So once again, this is one of the first cases on this issue, and there are likely to be more. So in the links below, I've provided some resources so that you can do some further research. One of them is the decision on summary judgment by the Delaware District Court. Another is a USPTO study on virtual marking. And I've also included the webpage address that includes all of the patents for plaintiffs' LCD display products that were the subject of this litigation. So I hope this was helpful, and thank you for watching.